Thank you very much.
Ladies and gentlemen, my name is David Curran. I'm Head of Financial Lines Claims with AIG, based here in Dublin. I'm a lawyer by profession, qualified in ROI, NI, and England and Wales. The reason I tell you that is to give you some evidence of hopefully the standard and class of person behind claims and liability underwriters within the jurisdiction, and especially with my own employers. I've been kindly asked here today to say a few words on my views and my employer's views and the insurance industry views in general on mediation. My own personal views are that I'm a champion of mediation. My employer's view, which tends to follow my view given my position, is they are champions of mediation. And my colleagues' views within the insurance industry is they welcome mediation, but there's some difficulties for insurers, which is a bar to them participating in mediation. I might just say a few words on that to you. First of all, I'm Head of Financial Lines Claims. What is Financial Lines Claims? Financial Lines is professional indemnity insurance for every conceivable profession in the jurisdiction, from solicitors, barristers, engineers, architects, accountants, to beauty therapists, to masseuses. The whole spectrum of modern day person who holds themselves out as a professional. We also, Financial Lines Claims is also deals with employment practice litigation, it deals with directors' officers insurance, and it deals with financial institutions like the banks and the building societies. So normally is me behind the lead stories in the Times and the Independent, unfortunately. Now, with these type of policies that we sell, AIG in particular, and there's other insurers in the market, there's no doubt, these normally involve our insured being large commercial entities who potentially out with the professionals but have a multinational aspect to their business. So normally boards of directors, normally management committees, quite high caliber people reach a certain stage in life, but of a certain business acumen and certain structured reasoning towards dispute resolution, towards litigation and control of their business. That's the type of sphere I operate in. They buy insurance, they obviously buy insurance to protect them against a claim of whatever nature comes against them, and the nature of the beast being human nature, claims can, will and do arise. So, you know, these large multinationals, and indeed professionals, and I know there's quite a lot of professionals here, they're loath to enter formal litigation. We're all great at participating in litigation when for the plaintiff or the defendant or whatnot, or being an expert witness, but actually being involved, being the main player or one of the main players in litigation. Insurers, whether it be multinational companies or professionals, don't like it. Insurers don't like formal litigation, and no disrespect. Just like Peter and Brendan and his colleagues in the court service, insurers don't like to be down around the full court or any other court of the jurisdiction if we can avoid it, because ultimately we're the paymasters. But insurers are pragmatists. If they're faced with a claim from one of their insureds and liability can be determined at the outset, they don't want protracted litigation, they don't want increased costs exponential to the claim. They're quite happy to engage in an alternative dispute resolution process. Insurers really do want to do that. Our large clients, our professional clients, want to do that. Of that, please be no doubt, we want to do that. But there's a difficulty. Professionals and large clients, boards of directors, control their own business, sometimes right down to the ordering of a barrel pen. So all of a sudden they don't like to hand out to third-party solicitors, barristers and experts control of their business, control of litigation, which could have a direct impact on their bottom line and their future potential to grow their business. They don't like that. So that is an obvious problem for insurers in general. When they're involved in the dispute, most insurers will tell me that They want to maintain their reputation. They want to pay as little money as possible, but at the same time achieve an effective resolution to the dispute. But most importantly, they want to maintain ongoing business relationships, whether it's a solicitor with a client or former client, whether it's a board of directors with a third-party supplier, or there's a contractual dispute with a business partner. They want to maintain relationships. So from this perspective, and I say this both as the insurer and being the person in receipt of quite a large amount of feedback, quite a large volume of feedback from our insurers, mediation is the perfect storm for liability underwriters and for the vast majority of companies and individuals, professional bodies who carry insurance. It is the perfect storm. It can provide quick resolution to disputes. It can be a cost-effective alternative. It can be a platform to allow continuing relationships. It can be conducted in a cordial manner. And most importantly of all, it's conducted in private. And it's subject to confidentiality, and it protects reputation. That's what mediation does. All the insurers of my employer and other insurers of other insurers within the jurisdiction will tell you the same. That is a perfect storm. That's what they want when faced with a dispute or a litigated matter. So why then is there a reluctance from insurers and from certain defendants to litigation to participate in a mediated process? And the reluctance is this, as I just outlined. No one likes to hand control over to third parties wholesale. They like to be a fulcrum in the defence of any piece of litigation, or they like to be part of the resolution process. They don't like to be on the periphery. They like to be in the epicenter. So all of that factored in, and the fact that the process is over-lawyered, it's grossly over-lawyered. From the insurer's perspective, it's grossly over-lawyered. The predisposition from insurers and from their insurers at the present time is the lesser of two evils, and that being the formal litigated route. You know what you get. It does exactly what it says in the tin. You get through the pleading process, you get through your motions, you get through your discovery process, and eventually it's set down for trial and you get on with it. Either arrange settlement talks or the matters placed before the courts. It's a defined process. Mediation is slightly inert at the present time in the view of me, in my view, and the view of insurers. In general, I would say, but they want to participate. I would say, in my own view, that the mediation process needs to be streamlined. It needs to be streamlined in such a way that, back to what Richard was saying on education, the participants in the mediated process, both lawyers, insurers, liability underwriting insurers, all need to be educated in that. It's about quick resolution of a dispute. So it needs to be streamlined, and there needs to be less red tape, less lawyers, and not the slavishly follow the formal litigated process. It is a process outside of the formal court litigation process, and that should be acknowledged, and there should be a different train of thought put into that mediation. It should not be the default position to a court hearing that at the end of the closing of pleadings or upon completion of discovery that mediation is suddenly floated as an idea and everyone runs to mediation. If there's an acceptance by all parties at the outset of a dispute or relatively early within the dispute that this is not for a judge, there's no case law involved in this. This is a quantum issue. This is a business relationship issue. This is a performance issue. Well then, let's engage in mediation at the outset. You know, don't rack up fees. Don't keep the meter running for the lawyer. And then all of a sudden, when there's an acceptable amount of money for fees due, then float the idea of mediation. That is the bane of insurers. And unfortunately, I've been on the receiving end of that quite a lot. It's actually refreshing that lawyers will come to us, our panel lawyers, and our lawyers nominated by our insurers, and will say, guys, you have a problem here. The other side, no, you have a problem, that's why they're litigating with you, proposing to litigate with you. I think you should engage in early course. Now, the last thing I will say to you on that is, the lawyer should be the advisor in mediation in my view. He shouldn't be the representative. Now, I think there's a clear difference. If you can imagine The Godfather Part 3, when Michael Corleone is called before the grand jury, Tom Hagen is sitting behind him. It's Michael Corleone providing all the answers to the questions from the grand jury. Tom Hagen is consigliere standing behind him, sitting behind him, sorry. And anytime there's an awkward question, he just simply puts his hand over the microphone as his lawyer and advises Michael Corleone what to say. But Michael Corleone is in the hot seat. It ain't Tom Hagen. He's the advisor, not the representative. And I think that's a scenario that should be adopted in the mediation process. Ladies and gentlemen, thanks very much.